Early signs of insolvency often appear well before a business formally fails, and recognizing these warning signs early is critical for directors seeking to protect both the company and themselves from legal risk. Insolvency rarely occurs suddenly. It typically develops through a pattern of financial deterioration, often starting with subtle operational issues and progressing into serious cash flow problems. One of the most common early indicators is persistent cash flow pressure, where a company struggles to meet day-to-day expenses or begins delaying payments to suppliers beyond agreed terms. Directors should also be alert to ongoing losses or declining profitability, which can indicate that the business model is no longer sustainable. Over time, this may lead to increasing debt levels, particularly where liabilities begin to exceed assets, or the company becomes reliant on external funding or director loans just to maintain operational. Another key warning sign is a change in creditor behavior. This may include suppliers tightening credit terms, requiring cash on delivery, issuing letters of demand, or commencing legal action. These external signals often reflect a broader loss of confidence in the company's ability to meet its obligations. Internal warning signs are equally important. Poor or incomplete financial records, an inability to produce up-to-date accounts, or a lack of cash flow forecasting can prevent directors from accurately assessing the company's financial position. Without reliable information, it becomes significantly harder to identify insolvency risk and take corrective action in time. Other indicators may include unpaid tax liabilities, superannuation arrears, difficulties collecting debts, and an increase in reliance on refinancing or short-term funding arrangements. While any one of these issues may not be conclusive on its own, a combination of these factors can strongly indicate that a company is approaching insolvency. Importantly, Australian law imposes a duty on directors to prevent a company from trading while insolvent, meaning that failing to recognise and respond to these warning signs can expose directors to personal liability. Acting early can preserve restructuring options, allow for negotiation with creditors, and significantly improve the prospects of stabilising the business. Because identifying insolvency risk requires both financial and legal analysis, understanding when these warning signs cross the threshold into insolvency and what steps should be taken next is critical to protecting your position and avoiding more serious consequences. Contact us today for a free 30-minute consultation with one of our experienced team of insolvency professionals and let us help you protect your rights.